Herkese merhabalar. Hello everyone. We'll be having a 2-minute waiting time so we can admit all participants. Thank you for your patience in advance. Hello again. This is İdil Bozoğlu, Vice President of STL Turkey. We're gathered here today for a very interesting session with Fatma Güney. Fatma will be talking about very interesting case studies, the Arbitration Act of 2025, and will later add some interesting points for greener arbitrations. I can personally say that case studies are eye-opening, remarkably referable, and are must listen. Quick note, you can jot down and type your questions to the Q&A below, and we'll be referring to them at the end of the presentation. Our speaker, Fatma, needs no introduction, but with a quick reference, Fatma Güney is an English qualified barrister and solicitor. She's a highly accomplished international arbitration lawyer, having spent the last 15 years in a renowned arbitration practice in Istanbul. Fatma specializes in infrastructure projects and FIDIC contracts, and she had been involved in high-value and highly technical arbitration proceedings. Alongside her role as counsel, Fatma is also appointed as arbitrator and has sat both as sole arbitrator and party-appointed arbitrator. Last year, Fatma relocated to London to join a firm specializing in international arbitration and is currently practicing in London, but remains very rooted to her ties and connections in Turkey. She was awarded Client Choice Awards, Global Thought Leader, and Arbitration Future Leader. Without further ado, I leave the floor to Fatma, but will definitely be asking direct questions. Fatma, the floor is yours.
Thank you very much, Idil, for that very kind introduction. So without further ado, I shall start with the presentation. So as you mentioned, this presentation is very much in relation to going through some highly interesting cases. And in respect of these decisions, in terms of their importance of the substantive and procedural aspects of construction disputes under English law, because we are very well aware that a number of these highly interesting projects around the world are based on the applicable law is English law. So it's very important to keep up to date with the latest changes in the law to accommodate this. So the Arbitration Act of 2025, the new act in the UK, this brings about new procedural rules. And this again is important to know when you're applying English law to the contract, to make sure that you don't fall into any of the pitfalls. And as you said, we may have some interesting facts and tips about the greener arbitrations. And then we have our question and answer, which is important. So for the first case study, we're going to look at an important case of 2026, so this year. which gave guidance on the proper interpretation of an analysis of variations, Section 20.1 FIDIC notices, and engineer's authority. So this case is called the Uniform Building Contractors Limited versus the Water and Sewage Authority of Trinidad and Tobago. It's hot off the press this year. It's a decision by the Privy Council, which is the court of final appeal for many Commonwealth countries. And the Privy Council considered key aspects of the FIDIC Yellow Book 99 edition. So just very quickly on the background, this was a pipe laying contract dated May 2007, and the claimant agreed to design, supply and install a total of around 30 kilometers of pipeline. The dispute arose between the parties, and the two packages in the contract were subject to a termination notice from the Water and Sewage Authority to the claimant, and this led to the claimant initiating proceedings against them. So the claims were relating to 4 items of work which the claimant said were instructed to carry out by the engineer as variations, which then entitled them to additional payment under the contract. So just to give you a concept of what these works were, they were laying pipe work for a road work as opposed to verges. So this would mean that there's a different type of method of working involved. The removal of excavated material deemed to be unsuitable as backfill, and then consequently the importation of suitable backfill, and night work. So this was the type of work that was being involved. So the Water and Sewage Authority argued that these were not variations at all, and that even if they were, the claimant failed to comply with the procedural requirements, the notice requirements of the contract, which were a condition precedent. And so they were not entitled to the additional sums. The contract had a large amount of documents, and we all come across these projects where there are millions of documents involved. This had general conditions of contract, which, as I said, was the FIDIC Yellow Book 99 edition, for the use on design and build projects. And there were also conditions of particular application under the FIDIC conditions, employer requirements, and the BOQ. Very interestingly, in the hearing, the engineer actually gave evidence on behalf of the claimant, stating and confirming that he considered these 4 disputed items as variations. But there was a very big problem about showing evidence of how these works actually came about. So there was evidential problems in this case. This case was appealed twice, first to the Court of Appeal. The Court of Appeal, interestingly, accepted that these were variations, and even accepted on the basis of the engineer's evidence at the hearing that these instructions amended the terms of the contract entitling the claimant to payment. The Court of Appeal treated the site engineer's approval of these items as varying the works, and in fact waiving the strict compliance with the contractual notice requirements. Then the Court of Appeal considered that the site engineer had indeed waived these contractual requirements because the authority, the sewage authority, was given the notice of change and no objection was raised. So the Court of Appeal considered that it would be fundamentally unfair to say that these were not additional payments. However, the Supreme Court completely reversed the Court of Appeal decision. So the Supreme Court found that although the Court of Appeal had decided that these 4 items were to be considered as variations, the Court of Appeal failed to refer to the terms of the contract. And it is only when you look at the terms of the contract and you consider these terms that you can decide whether or not it's a variation. Also, it was decided that the engineer's conduct of waiving the contractual requirement was wrong. as it failed to give the full effect to the terms of the contract, and I'll explain that in a bit more detail in a minute. Thirdly, there were problems arising out of the Court of Appeal's approach to the issue of this waiver and estoppel in terms of what they called fairness. So, unfortunately, this fairness issue, which is actually a very important aspect of submissions that are made in claims in the recent times, was not actually pleaded in the first place and was not addressed in evidence or raised before the trial judge. So, in fact, this was something that came about later on, but because it was not officially pleaded, it could not be taken forward as an argument on behalf of the party. So the Privy Council, the final authority, had three tasks to do. It had to consider the nature and scope of the general terms of the contracts between the parties and see exactly what might have been expressly or impliedly included in the lump sum. So they had to go back to the contract. Secondly, they had to analyze the procedural failings on behalf of the claimant in relation to the notice provisions and the extent to which this barred them from making any claims for the four disputed items. And thirdly, in relation to this general issue of fairness, in particular, how and to what extent that the question of waiver or estoppel arose or could have arisen in the case. So the Privy Council finally concluded that these four items were not variations to the employer requirements or works, and the Privy Council set aside the Court of Appeal decision and dismissed the claim in full. So it is the takeaways from this case that we need to really earmark are, for example, if we focus on the clause 20.1 notice provision, the courts from this case is very clear now that they will treat notice provisions under clause 20.1 of the yellow FIDIC or any other suit as a condition precedent. So it has to be fulfilled before an entitlement can arise. And FIDIC clause 20.1 can be readily enforced, and compliance with condition precedent to payment in a FIDIC contract is essential before recovery. The language, go ahead.
Wait, I'll interrupt in a minute.
Okay, so the language of 20.1 of FIDIC conditions is in classic condition precedent form. And so the clauses which require a specific provision to be fulfilled before a corresponding right occurs is to be construed as a condition precedent. So the contractors must be very careful to ensure that notice requirements are complied with, and especially where there's a condition precedent, they should not then try to retrospectively rely or try to establish that an estoppel or waiver has arisen.
Yeah. Well, here I have to make a note and want to really ask a question. It's an exceptional case in terms of the Court of Appeals decision, I guess.
Yes.
But you made a very beautiful statement. You said showing evidence was important here. I'm going to ask you a question about the creating the documentation part, because I know that as construction lawyers, you have 100% went the same way. Due to circumstances on site, there are times, there will be times when the contractor on site act on impulse.
Yes.
And quick decisions. So non-lawyers, of course, and especially with respect to variation instructions, like the first act is not to define it or to document it, but act on it as soon as possible. What advice would you give to the contractors on site, non-lawyers maybe, in this particular situation?
That is a very good point, Idil. I mean, we see it all the time. Unfortunately, there's an ideal world and there's a fanciful world where we can all sit down and make those nice little requests and emails and everything. But the situation you're talking about is very real, and site managers go through this every day of how to best do the contract management and how to best respond to a variation request, even if it's an oral one. But at the end of the day, if you are before a tribunal or a judge, you need to establish that that was one, a variation, and two, that you agreed to be paid for it. It was agreed. Yes, it's very difficult contemporaneously to put together that mindset, but there are two types of entitlements that you need to prove. One, the contractual entitlement, and two, as I say, the quantum. So in terms of the contractual entitlement, for non-lawyers, in that situation where the engineer comes and says to you, can you do some extra work, or can you just do this, and it's literally oral, you still have to know your contract very well. So the rule number one is you have to be very well aware of what is written in your contract regarding variations and how the procedure for variations works. So in the very instant that you get that instruction, you already know in your mind the type of things that you need to be erring to in order to make your position safer. Yes, it's always easier to just quickly do the work and then later on, maybe retrospectively, then put together something. But at that time, if you are aware already of what your contract is saying and how the procedure is meant to work, then it's a lot easier to put together the evidence of what you need to constitute a variation. So in terms of the quantum aspect of it, of course, we don't, no contractor does work for free or expects it to be free. Everyone needs to be paid for the work that they do. But you and I see it all the time where work is done and substantial work is done, and at the end of the day is valued as zero because of either the procedural aspect or the quantum aspect. So it's very important that some time is taken to put that documentation together. Firstly, one of the biggest disputes we see in the hearings and the claims is that one side will argue that that work was already in the original scope. Okay, so firstly, you have to put together the documents to ascertain that this is actually a variation. Secondly, the documents that you maintain whilst you're doing the work. So instead of compiling them at a later date, as you're doing the work, so you're maintaining contemporaneous records, you're getting the written instructions, timesheets. Timesheets are very important. They're very, very effective when used at a hearing. Invoices, photographs of works having been completed, etc. Site minutes, variation orders, change orders. A lot of these things can accumulate to you having evidence rather than later on trying to scramble back in time, trying to make them up. So the common pitfalls here is failure to provide the requisite documents for the further work and the agreement as to costs. And it then turns into the contractor carrying out the works on a verbal basis and the engineer literally denying that they were ever instructed to do the work. When rates are used as well to measure the quantum of the additional work, those rates must be agreed or justified, because we get a lot of disputes where the work is done, even the payment it's agreed that it would be paid, but the rates are not agreed. And then you end up getting a lot lower value than you expected for having done that work. And maybe you wouldn't have done that work in the first place if you knew that that was the profit margin you were getting. So some of the things to think about.
Preparation first.
That's it. So the next case I'd like to move on to is regarding claims for additional payment, again, a similar theme under FIDIC and FIDIC type contracts, and this issue of course of dealing, which is important. The case of 2025 is Dipcon Engineering Services Limited and Urban Development Corporation, again of Trinidad and Tobago. So the issues here were that Dipcon, an engineering services company, they contracted to perform some infrastructural works at a housing development for a value of around £26 million. So the contract incorporated FIDIC conditions of contract for civil engineering works. And then there was a period of negotiation wherein the Urban Development Corporation proposed to pay a settlement sum in full and final settlement of all claims relating to the project. So Dipcon the claimant accepted this agreed sum, but then requested consideration of an additional £12 million. So this subsequent reassessment was done by the respondents' officers of the company, and they later reassessed this claim and then denied liability, which meant that Dipcon had to take them to court. So the issue of this, the central question, was whether the Urban Development Company was liable to pay this additional sum in addition to the agreed sum under the FIDIC contract, specifically through clause 70.1, which provided for additions to the contract price in respect of rise and fall in the cost of labor and materials as determined in accordance with the contract conditions. So there was actually a particular clause that was referred to in this claim. So this is another Privy Council claim case, and the Privy Council dismissed the appeal, finding that Dipcon failed to establish its entitlement to additional payment on two bases. Firstly, it was held that according to the provisions of the contract, when you look at the clauses very carefully, the Urban Development Company could only assess and verify claims through its board of directors, and no such board assessment had occurred. And then secondly, under the course of dealing argument, because Dipcon put forward a course of dealing argument, the established pattern required the board approval of payment, which was never obtained. So the course of dealing argument also failed. So going into this in a little bit more detail, the claimant argued that the additional payment fell under clause 53.4 of the FIDIC provisions, which provided that if the contractor fails to comply with the prescribed claims procedure, its entitlement payment shall not exceed the amount as the employer assessing the claim to be considered by contemporaneous records. So Dipcon, the claimant, contended that since it had not followed the proper claims procedure requiring the 28-day notice near, clause 53.4 allowed the parties to deal directly. So you could kind of put the contract aside and then go directly to the parties for the reassessment, and that this constituted a determination. So basically what the claimant tried to do was avert the contract, go behind the contract, and try to say that, look, we don't need to worry about these procedural aspects of the contract. We've done this before. We can sit down together and look, we've already agreed the agreed sum, the full and final payment. Let's just agree this additional amount as well. And we're not talking about a small amount either. But the Court of Appeal analysis rejected, the Privy Council rejected the Court of Appeal's analysis for two main reasons. And this was predominantly that everybody was aware that the contract clauses very clearly stated that only the board could make a decision in respect of the claimant's entitlements. And it was only through this organ, it's a matter of even basic company law. The absence of a delegation of powers means no entitlement. So they lost from that aspect. And secondly, the fact that the defendant's employees conducted the reassessment, this made it even worse because it meant that they didn't have authority to bind the company into any decision. So the board approval requirement basically meant that the claimant failed in its claim. The court also emphasized that the lower courts found the claimant was very well aware and knew and even acknowledged that board approval was required for such additional payment and for such entitlement to actually arise in the first place. This case is important because it confirms that if the lower courts find a finding of fact, then the higher courts, even the Privy Council, the last appeal stage, cannot actually interfere with those findings of fact. So if they found that the claimant was already knowledgeable about the board approval matter and they knew that this was the procedure, then that fact carries up until the highest state of the proceedings, and you can't really get rid of that. The alternative argument, the course of dealing argument, was also very interesting because the claimant tried to say that, look, guys, these parties have done this before. They've deviated from the contract before. They've deviated from the FIDIC procedures before. And so there is an established pattern of the parties dealing with each other directly. But unfortunately, this didn't bite too, because it came back to the fact that without board approval, you can't go very far. So this reassessment didn't actually get anywhere. The third thing I want to highlight about this case being important is the fact that, and we see it often, Idil, you'll agree with me, that a number of cases sometimes are premature because the parties fail to follow there's either multi-tier contractual clauses, or there are a number of factors to do before you actually get to an established right. So what we say to this is, has the claim crystallized? Has the entitlement crystallized? So if the entitlement hasn't crystallized, then you're not going to get very far with the claim. They're going to say to you, go back, make sure you've done what you need to do according to the contractual provisions, and then present this case. So in fact, the fact that the entitlement to the additional claim hadn't crystallized because the claimant failed to follow the procedure through, this was in itself enough to dismiss the claim anyway. So those are the key concepts under this case that I wanted to highlight to you.
Mind the steps, Fatma.
Mind the steps, exactly. Nice conclusion.
I want to ask a question about FIDIC-like contracts as well, because we run into them every day, especially in Eastern Europe.
Yeah.
So from this case and what you have summarized, what I understand is that we need to be cautious about claims for additional payment, as well as additional time for variations in instructions. It doesn't always mean additional work also. Variations, they don't mean additional time and payment together all the time. What are your views on how or what a contractor should be careful if they want time and money for a variation at the same time for a FIDIC-like contract?
That's a very important question. And I think the fact that we all know that additional time does not automatically mean that you get the money. So I'm going to track back and say what I said in relation to the previous answer, which is you must firstly know your contract. So if you believe that you are entitled to additional payment, the first thing you need to do is make sure you get those procedural steps right. whether you need to send a notice, a set of notices, subsequent notices, in order to at least pass the procedural step of that. You must make sure you comply with it. It's easier said than done sometimes, because sometimes you have contracts, like you say, FIDIC type contracts, but they've become very complicated because they're either government based or they're based on some kind of standard form contract that you didn't really have much of an initiative to make an amendment. It was a take it or leave it situation. So where you have these, instead of having the attitude of, well, there's nothing I can do, I had to sign this contract, this was put in front of me, the more you know about your contract and the more you know about your rights and obligations under your contract, especially when it comes to requesting additional money, because in some contracts you have clauses where you're actually prevented from claiming additional money for certain items of work, and you have accepted that you're not going to make any claims for that. But it could be that in a different provision somewhere else in the contract you can recuperate that right. But if you don't know about it, then you're not raising that as an entitlement. So knowing your contract is actually extremely important. In as the topic is English law, as English law, under English law, the contract is king. So that's always going to be the starting point. So where, like the cases that we've seen, if you want to deviate from the contract, then you have to show that it's not a unilateral aspect, that both sides have very, very openly, expressly agreed to deviate from the terms of the contract, and then you're safe. No one can argue that, or you don't even need to worry about impliedly showing. You need to make the steps to show that that part of the contract has now changed mutually, not one-sidedly, but mutually, and the change is X, Y, and Z, because the onus of proving this rests on your shoulders. The other side are going to be very comfortable. They will sit down and say, we didn't say that, we didn't do that, there is no evidence. So it's up to you to present that there is evidence that, yes, it has been changed. The course of dealing argument is sometimes is a bit of a trap, because people, when the project is ongoing, is fast moving, there's lots of different elements of the project ongoing at the same time, sometimes contract managers could confuse or mistake course of dealing for something that they believe was the case, but actually it's only in their mind that that's the situation. If you ask the other side, they will say, no, there is no pattern of change, the contract is the contract. And what do we see all the time? However much on the site, the contractor is told, don't worry, just do the variation, you'll get your money. In the hearing, they say, what variation? So it really is up to you to put together those steps, mind the gap in terms of any procedural aspects, know your contract, and you'll be in a much safer position at least.
I couldn't agree with you more. I'll have to underline this. Maybe this is the most important part from this case. We have had a chat about this. We have discussed this. Contractors feel the burden of actually knowing that they're going under a hard term and somehow keep running away from those terms. So yes, maybe you had to sign it as is. It's a big contract, governmental contract, but being prepared and being having maybe worksheets for the people on site, how to respond to some requests or what to do is more than beneficial. I couldn't.
Yes, absolutely. And it's surprising how effective a timesheet is when you present it to the tribunal. I mean, if you have a timesheet which is contemporaneously put together of the workforce, the labor, the manpower, it's so much more easier than trying to explain the story without that evidence, because it just becomes a story.
Exactly.
Great. Okay. So the next interesting case concerns the question of whether contractors can terminate for repeated late payments. So this is quite important. Let's see what case it was. So this is the case of Providence Building Services Limited versus Hexagon Housing Authority Association, Housing Association Limited. And here, the essence of the case was that the UK Supreme Court settled the position under the English design and build contract by giving a judgment allowing employers operating under this standard form contract to proceed with some form of certainty that late payments, which are very quickly corrected, will not automatically give rise to a right to a contractor to terminate for under the contract. This case was very much about contract interpretation and not acting outside the remit of the contract clauses. So you'll see the pattern of these cases coming out. They're all talking about stick to your contract. What does your contract say? If you are operating outside the remit of your contract, then you're not going to succeed. And in fact, you're going to get lumbered with costs and all sorts of negative implications. So this particular case fell on the correct interpretation of two specific notice clauses in the contract. However, the rule applies, like I say, across the board to all type of contracts, FIDIC type, FIDIC contract, FIDIC type contracts, and similar. So the contractor sought to terminate this contract based on these notice provisions, arguing that the second late payment entitled them to do so. But actually the provision dictates that such a right will only occur if the first payment was more than 28 days late. So the employer, in this case, made payment within that time, but he defaulted again for a second time on the next payment. So where does this leave the contractor? The contractor thought that he could use this second default on the same notice that he gave for the first default, and then say, well, I've already given my notice for the first one, so now I'm entitled to terminate. But unfortunately, he could not rely on that first notice he had given, because that was for the first default and it was addressed in time. So remember, there was a 28-day period for making that payment, and the employer paid. They paid after a few days. So basically here the claimant, very brief background, they engaged this housing association, and the housing association failed to pay a notified sum by the final day for payment, and then the claimant issued a notice for a specific default under the relevant clause. Like I said, the employer then made the payment within 14 days, so they were in time. Subsequently, like I said, the respondent then failed to pay a second time, and then, like I said, the claimant purported to terminate the contract, relying on the first one. The matter was actually referred to adjudication, which found in the respondent's favor. They were unsuccessful because they referred the matter to the judge, and the judge held that in order to exercise the right to terminate under that specific clause, they must first have obtained the right to terminate under the first clause. So this is what's happened. What they've done is they've mixed up the clauses. They've purported to use the notice that they had given on the first occasion to make an entitlement to the second one. But unfortunately, that's not what the contract says. And also, if that was the case, that would be actually quite tough for an employer, because it would mean that for a very short period of time, if they didn't pay, for example, in 2 or 3 days, then the entire contract could be terminated. And when you look at it on a commercial point of view, that doesn't make any logical sense either. So that's what the Supreme Court said. The Supreme Court said that the Court of Appeal's decision wasn't logical because it didn't follow the logic of what the notices actually were trying to do, and also the fact the employer had already paid within the 28 days meant that actually that put a stop to that, and it started the process again. So you couldn't really use the contract in that way. I liked the phrase that all of these cases are readily available online if anyone wants to read through them, because there is a lot of detail in these cases, and due to time, I'm just trying to give a snapshot of them. But one of the phrases that I liked in this was using a sledgehammer to crack a nut. So basically, the Supreme Court judge said if we were to follow the Court of Appeal's logic, then it would just be overly disproportionate to what the rules or the contract is trying to achieve.
Fatma, can I interfere here? Coming from a civil law jurisdiction, of course, you would understand how we react to English law contracts at times. Set us aside on that thing, but what tips would you give to a non-lawyer when interpreting the contract laws? Because it's so different from how we interpret and how we deal with these kind of procedural issues. Procedure, of course, is king at times, surpasses merit by times, but at the end of the day, we have the power and authority of the judge arbitrator who has jurisdiction over that. But in English law, something else is king, I guess. So what is the tip that we can give to a non-lawyer on this?
That's a very good question, Edith. I think these cases in itself show that even the parties can get very confused, because look, the Court of Appeal decisions are being reversed by the Supreme Court, and then you've got the Privy Council decision then coming in and saying, well, that's not logical. So even at these stages, the courts are interpreting them based on different aspects. But I think the best approach would be, with English law, it's a very black and white. Whatever the clause says, that's what it is. But sometimes there's room for some ambiguity in some clauses. So when you read the clause, it's not automatically clear where that clause is. And of course, whichever side you are on, you are going to want to interpret it in your favor or in your client's favor. But that's not necessarily always the right approach, because it could be that, like we've talked about, these contracts that we've had to sign, take it or leave it type of agreements, we've had to sign very heavy clauses that are not necessarily in our favor. And yes, we're trying to make the best of it, but if we interpret it wrong, or we do something wrong, not in accordance with these provisions, then we end up in court and we end up with the disputes. So, I mean, the best thing to do is, if it's not a very clear clause and the language isn't very clear, and especially if you're aware of some other clauses in the contract which may actually contradict with what's going on with what you're trying to achieve, then it's best to take professional advice about how to go about it, because it's better safe than sorry, to be honest. Sometimes you need some consultation about how these work, because the good thing about English law and English law applicable contracts is that at least you know when the case hits the highest authority, that is a precedent. So you use that as an example of, if you have a clause that you're not sure which way is going, the cases are going to lead you in the direction of where that would go if that ever became contentious. But yes, I think sometimes we all need to take a bit of advice.
Thank you. Thank you so much.
So the next case is regarding, again, similar theme, the importance of having a physical signed contract for the works that have been undertaken. Now, this is an interesting case, High Tech Construction Limited versus WLP Trading and Marketing. This is, again, a case of this year. And what happened in this case is that the court declined the summary judgment. There was a judgment in the hands of the claimant of 2 million, and they tried to enforce this, but unfortunately the court said there's no contract here, so it's unenforceable, and they rejected the enforcement. So that 2 million award in the claimant's hand was literally worthless.
In there.
Yeah. So very quickly on the background of this one, the adjudicator was appointed by the Royal Institute of Chartered Surveyors. The adjudicator determined that the claimant was entitled to payment of this sum of money for actually substantial construction works that had been completed between 2023 and 2024. And the claimant took this decision in its hand and took it to the High Court to enforce it. The court was required to consider whether the adjudicator had actually firstly had jurisdiction to decide a dispute in circumstances where one of the parties actually argued that there was no contract in existence in the first place. And as I've said, the court then found that the summary judgment was not enforceable because of the non-existence of the contract. This case really does highlight the difficulties which can arise where a formal contract is not agreed contemporaneously and not signed by both parties before the commencement of the construction works. And sometimes it can be a little bit complicated because you think, well, of course you're going to have a signed contract, but there are lots of situations where the works on site are ongoing, and maybe there's another aspect of work that is being agreed newly between the parties. But if that aspect of work isn't documented somehow, then it doesn't exist. So in this case, it wasn't really the content of the contract that was the problem, but rather the existence of the contract itself. So very quickly, what went wrong here? Two aspects were wrong here, and I advise anyone to go and read this case as well. This was also a very factually interesting case. So the defendant here argued that there was no binding contract. No binding contract was ever agreed, and in fact argued that the contractual arrangement that the claimant keeps putting before the court was based on a sham and fraud. So there was an element of fraud in this case. The second problem of this case, as I've mentioned, was the jurisdictional defect. So where a contract doesn't exist in the first place, and especially where there's element of fraud, then an adjudication cannot possibly validly proceed. So actually, that adjudicator, having been appointed in the first place under those circumstances, was effectively a waste of time because there was nothing to adjudicate because there's no formal contract. And it was decided that any adjudicator appointed on the basis of the notice given by the claimant would have no jurisdiction to act, and any purported decision would literally be a nullity. So this made the adjudication procedure very uncertain. It left the notifying party open to jurisdictional challenges on enforcement, and ultimately it meant that the £2,000 to £2 million was not recoverable. So it was not a happy ending for that one. Moving on to the last case then, and this isn't necessarily a construction related case, but it is a very important case of this year, again, hot off the press. And basically, the essence of this case is the Court of Appeal decision confirming the finality of awards. In this case, there was a very this was a share purchase agreement case, and it had a particular arbitration clause which included wording such as the tribunal had authority to amend and add to or change the judgment at any time. So the court found that this wording, especially the at any time part, was fundamentally incompatible with the Arbitration Act of 1996, because every arbitration has to have a final. Every award must be final. So the key takeaways here: an arbitration agreement must contemplate that a tribunal will make a decision which is binding on the parties and final. In the Arbitration Act, final means final. So you have to be aware of that. You can't give powers to tribunals to at any time swap and change the awards. And I think the ruling highlights that the importance of ensuring that the arbitration agreements are drafted to allow awards to become final and binding. So just a word of caution here, when we're looking at the contracts, also remember the arbitration clause and have a look at the wording. If there is anything that resembles power beyond anything final of an award, you must appreciate that that is going to affect enforceability of any award that you could get. So it's very important in terms of making sure that you get an enforceable award, to make sure that the wording of your arbitration agreement is sound. So I think that then concludes our case studies. It did.
Thank you very much for this, and I'm excited to see what the Arbitration Act brings us, and why is it important for us to hear.
Great. So, very quickly, the key elements of the new Arbitration Act of 2025. So the first one is the fact that there is a provision of summary disposal of claims. Now, this is a notion that is very familiar with the English legal system and the English courts. So when you have a claim or a defense in the English legal system, if there is absolutely no prospect of success of this claim, then you can go to the court and ask the judge to strike out the claim without having a trial at the very, very beginning. So this process has now worked its way into the Arbitration Act, which means that the tribunals now expressly have the power to dismiss claims or defenses that have no real prospect of success on a summary basis. The default law of the arbitration, the law of the seat. So if the parties have not expressly chosen the law governing the arbitration agreement, the new default rule is that it will be governed by the law of the seat of the arbitration. So where previously it was silent, now is governed by the seat. Then the duty of disclosure. This has probably come about from a number of cases where there have been some judges or arbitrators who have been in compromising positions due to not disclosing previous relationships with parties. And so now in the new act, there is a mandatory disclosure, and it's an objective test where arbitrators must disclose circumstances that might reasonably give rise to justifiable doubts as to their impartiality. And it covers the circumstances the arbitrator should have been aware, including appointments that they had previously. Mm-hmm. And then we have the enhanced powers for the emergency arbitrators and courts. This is important because sometimes it's very necessary to apply to emergency arbitrators, and they have been given more extensive powers and express powers under the new rules to make preemptive orders. So there are orders that are very familiar in the English legal system that now have been adopted in the Arbitration Act that are enforceable in the court. And the tribunal are now empowered to use. So that's a very quick run through of the key elements of the Arbitration Act.
Thank you so much. Especially the last two is quite important, I guess, because the interim injunction issue is
Exactly.
always a very important issue, and its enforceability when it comes to arbitration is another case. About the duty of disclosure, it's a question that always gives rise to me as in Turkey as well. I cannot imagine how it's in the UK. It is a lot to disclose. Sometimes a small circle at the end of the day. So, gray explanations, gray requirements, I think will create more issues than resolving anything because things that could be in compromising positions, like it differs for everyone.
Yeah.
And it's not a problem to disclose all kinds of acquaintances, all kinds of things that you have in common with the parties or the council. But at the end of the day, there's always a risk that the party who's not happy with the outcome to use it at that point. So, good faith, I think, is a very important point in practice of this as well.
Yes, exactly. I mean, there's always the IBA rules to fall back on, where they have the traffic light system expressing what kind of disclosure is necessary. But I think this provision has come about because there's been some untoward things happening, and just to make sure that if you believe, as a reasonable person, as a reasonable arbitrator, that you should disclose something, then you should have done so. So
Yeah.
it just enshrines it in the law.
Good to know. Good to know. Thank you so much.
So the last point, we have time, Idil, to very quickly go through the last point.
Let's touch upon this, and we have two questions referring to the.
Okay, great. So
Back.
very quickly then. So campaign for greener arbitration. So the first issue is the fact that a study was conducted by a steering committee last year for the campaign for greener arbitrations, and it's circled worldwide. And a lot of law firms and arbitration practitioners have become involved in this. The study revealed, very interestingly, that the carbon footprint of a medium-sized arbitration, so something valued between $30,000 to $50,000 approximately, you would need to offset the carbon footprint by planting over 20,000 trees. So this statistic literally blew everyone's minds. So you're sitting in, consider how many arbitrations we've all done so far. If you just think of one of those and think that you need to replant 20,000 trees to offset the carbon footprint, it is quite mind-blowing. So the arbitration world kind of sat back and said, well, what do we need to do for this, and what can we do to address these? One of the ideas was to put together a model green procedural order. So what is this? This is a document. We all know what the procedural order is. So the procedural order is the document that contains how the arbitration is going to pan out from start until finish. It could come in a number of forms, but on this particular type of procedural order, the arbitral tribunal are given powers to be more proactive in terms of leading the parties down a more efficient, not just for time, but cost as well. So basically, they would have more powers to decide whether certain applications are necessary or not, whether they're time wasting or not, and maybe even award a cost order to the offending party if they are acting outside of the remits. So this document gives the arbitral tribunal a little bit more power because usually you know what they're like. They're very intense on the due process, making sure that the enforceability of the award, etc. And they're a bit scared of trying to push the parties to behave. Really, sometimes you have very non-behaving parties that literally run up costs as if there's no tomorrow. So in terms of the cost aspect of this, that's why I wanted to bring it up, because there could be elements of this that parties might want to investigate, especially if they've got a very difficult counterparty who has a much larger purse and is very more willing to run the course of the arbitration than the claimant is. So this was interesting in terms of generally the practitioners are thinking, what can we do to assist the environment and also make the arbitration a bit more user-friendly. One point to note, though, a lot of since this the sustainability issue has become a larger concept, and the arbitral institutions are also they are looked upon to say, what are you doing? What is your contribution to making this world a better place? A lot of them now, especially the LCIA, and I think one of the Hong Kong arbitration centers, SIAC, they have introduced a documents-only procedure, expedited procedure. So that's great, where you have a simple enough arbitration. But this particular case on the screen, Wan Sun Metals Industries, was an example of where the documents-only arbitration didn't work, because it was all based on pleadings only, and the arbitrator made her decision on paper without hearing the parties. And unfortunately, at one point, the arbitrator used her initiative to make an argument which the parties hadn't in fact made. So what then happened was she made her award based on an unpleaded case that she found in favor for. And of course, upon appeal, that was dismissed and it was unenforceable. So the point that was made in this was that arbitrators, if you're going to conduct a documents-only arbitration, you have to be very cautious. You have to be extra vigilant in terms of what the parties are putting before you. And if you think that there is something to clarify, you need to bring that up instead of, putting it forward as if you're a party representative. The last point was that the GAR and LCIA sat together with a number of esteemed arbitration practitioners and arbitrators, and put their heads together in a session called whether arbitration has lost its way in terms of time and costs. So everyone is talking about the same thing. Everyone's trying to get to a certain point in it. But of course, I think the one thing to emphasize, which came as a result of these discussions, was that it was very difficult to control the parties, because the parties are acting for their clients and they've got their clients' best interests at heart. And sometimes it's difficult to factor in environmental issues where you have extremely large projects and large amount of documents to go through, etc. But the tribunal were targeted, and the result was that the tribunal should be much more proactive and lead these parties in a more efficient manner. So if they're seeing that one party is really behaving bad, they should act on it. They should be brave and act on it, because that's the only way that the arbitration is going to become more efficient. So they did publish 21 recommendations for trying to resolve this issue. They're very interesting recommendations. One of them, I'll only tell you, is that they encouraged, for example, party representatives with decision-making powers to attend the initial case management conferences, because then you have a set of authorized people to make decisions much earlier on than the later stages. So they're all on the internet, very publicly available. So I would recommend reaching out and having a read of those.
Thank you so much, Fatma. Maybe this is the one. This is the one subject that we should comment on more, because it really belongs to the future. It really belongs to our kids' future. If I can take 1 minute of this point, I would like to say that we need actionable points. As we had discussed and had chats before in our personal life as well, as counsel and as arbitrators, you and I both experience both. We need to protect our clients' rights and our reputation as both counsel and arbitrators. So maybe we should call upon the arbitral institutions more to focus on this topic as well, because so long as we want to take action on this, we have to have the client's interest, the best interest at heart in the first place for the first 6 points, and then go back to the reality of life. And another point, if I'm not mistaken, your case here is very important as well. It reached a point of exceeding powers, probably.
Yes.
It's it's a very important case that we should keep in mind. If you're available for a little bit of more time, that we have two questions. One is for our first case. Although the contract is FIDIC based, why was the dispute handled by the Court of Appeals and the Supreme Court instead of arbitration? And how long did the entire process take? I believe it was a set aside for our first case.
Let me just bring that back up.
Okay. So uniform building contractors.
Yes, exactly.
It was set aside, that's why.
Yes, exactly. So this was a Privy Council case. So the Privy Council are able to hear cases from the Commonwealth jurisdiction. So this is a Trinidad and Tobago matter with a FIDIC contract and clause 20. So it was appealed, and then the appeal was then appealed to the Privy Council. So that process in itself, this is why I'm saying that we are giving a lot of emphasis on knowing the contract and knowing exactly what the procedure is. But the procedure in the UK of going through all these steps of appeal itself takes years. Takes years, and you have to have the financial and the mental stability to go through. This is why these cases are so precious, because actually they give us the principle and they say, look, this is it now. So if your conduct is anything other than the principles, of course, if the facts of your case apply, because if you have different facts of the case, if there are distinguishing factors, then of course this case wouldn't apply to you. But if it's very similar and the principles are similar, then this is the authority that you need to bind your mind with.
Exactly. Thank you for this. And our second question is, I guess, about DIPCON. Notice period is missed. Can the court arbitration always reject the entire claim due to failure to submit the required notice in time? What is the common practice?
That is a question that we could talk about all day, the answer, but I'm going to give some tips about that. So sorry.
This shall be our next session, Fatma.
Exactly. Nice one for the next session. So basically, notices are a very complex matter. You either have a very clear and simple FIDIC type notice, or FIDIC type notice, or a bespoke notice, whatever the case may be. If you haven't, under English law, if you haven't complied with a notice which says that unless you do this, then your entitlement arises or doesn't arise, that becomes a condition precedent. And this is why this case was important, because it made the principle that from now on, if you have a clause 20.1 FIDIC or FIDIC-like notice, that is a condition precedent. And if you don't comply with it, your entitlement is not going to arise. So where you have notices which do not contain condition precedents, and what I mean by that is, like I said, if you the wording of the clause will be unless you do this, or if you don't do this, then the entitlement will not arise. It's a normal notice. Then maybe you can use other arguments such as course of dealing, such as fairness, such as waiver or estoppel, to overcome the fact that your notice was invalid or not proper in any way. But because in this particular case the notice was a condition precedent, nothing helped them. The waiver, estoppel, all of those course of dealing, none of that was applicable. And in this case as well, we had the extra added problem of the board having to authorize any additional payment. So you really have to look at the clause itself and see how the clause binds you and how it binds the other side. Where your entitlement arises, has your claim crystallized?
Exactly. And many others.
And many other things, yeah. For our next session.
Hi. In split contract structures, particularly offshore, onshore EPC arrangements with an umbrella or similar linking agreement, what are the key practical risks or pitfalls that employers should be mindful of? Thank you. Yeah.
Very good question. And we see this a lot. There is no simple answer to this unless you see what kind of structure that split gives. It's also very depending on the status of the parties. Is it a joint venture? Is it conglomerate? What kind of parties are involved here? And it's important how the party, for example, if you have a counterparty with more than one party, it could be that you have issues of joint and several liability. It could be issues, or it could be different issues. But definitely you would have to make sure that your entitlements are covered in terms of what you can claim for and how you can claim for them, because these split contracts are not necessarily, sometimes people confuse them and automatically think that one part of the contract will comply with the other part, especially with EPC arrangements. But it's not necessarily the case, and especially where you have more than one party. So we have multi-parties and you become in a dispute, it becomes very complicated. And even think of where one of them has become insolvent, and then you've got lots of other issues to deal with
there. Thank you so much. I think it was one of the best sessions that we had so far.
Wow.
Thank you very much. All of the cases are quite important. As you said, most referable and online. But the thing that we can underline is always be prepared. And it all comes down to the same thing, because they're classical for a reason. So being ready, being prepared, and having the right counsel, having the right assistance maybe might be the solution, not the solution to all the problems, but might be the right way and right methodology to actually for the life cycle of the project. Thank you so much, and thank you for our viewers to stick with us for such a long time, almost all. See you in our next sessions.
Thank you very much, Adil, for having me. Thank you, everyone, for participating. All the best. Bye-bye.
Bye.